Here is the stately title. There are a couple of seats up in the front. You all remind me of my first-year students who only on the greatest of provocation will ever come to sit in the front of the room. Here comes a bold and imaginative soul who will take one of these seats going once, going twice. Thank you so much. Anyhow, it really is a very great pleasure to be here and to talk about this little book. I should say it is in part a prelude to a bigger book which I'm now working on called The Classical Liberal Constitution, which has as its modest objective trying to give a comprehensive account of every major constitutional issue from the time of the founding to the president, and I hope to be back with that one in about a year or so. It's almost done, but events kind of push you very hard. But look, there's no point in being very modest about these proposals. You might as well try to do your very best. If you're going to fail, you should fail in the grand way. The greatest sin of an academic is insignificance, and so I would rather be mightily wrong than narrowly right in terms of the way in which I go. I much prefer to be broadly right rather than broadly wrong. And in fact, I am relatively a lone speaker in the academics. I was talking to several people before, and I said, giving some of my constitutional views, and I said, I don't think there's a single major constitutional academic who would subscribe to my basic framework. And so I think that's something about the power of your persuasion. But that then gets us to the current talk, which is that one of the things you could say about my views is they have no responsibility because they've had no influence in the current state of affairs. And when you start to do this, it's really quite striking, because what I did when I tried to position this book in the intellectual universe is to contrast it with other works that have come out. And what are these kinds of works? Well, there are very many important legal scholars who are essentially a populist in origins, who believe that we the people, not we the courts, ought to decide everything. My former student and the current Stanford dean, Laurie Kramer, is somebody who's in that particular tradition. Sandy Levinson, now at the University of Texas, has basically argued for a Jeffersonian constitution that you revise every year or every 20 years with an elite group of 700 individuals, none of whom know what they're talking about, except for where the hotel entrances may be. And then there are other people who say that if you really understand originalism, it's a completely dynamic subject, so that what you can do through a series of artful conventions is to take a classical liberal constitution and convert it into a modern progressive one, which vastly increases the scope of government power. Then you have the conservative judicial restraint types, and their central principle of interpretation is to take broad clauses and read them narrowly, lest you make sure that the courts have a significant role to take in limiting the way in which the legislature should operate, because everybody understands that national solutions require national problems, and this is at a time when Congress has a general approval rate of 11%. So there are these very sort of powerful antinomies. And my purpose, my somewhat lonely purpose, for which this audience, shall we say, is uniquely suited to be sympathetic for, so if I can't carry the day here, I will simply fold up my tents and go home, is to see if you can revive the classical liberal tradition in some sense. And so the title of the book, Design for Liberty, Private Property, Public Administration, and the Rule of Law, is designed to do this. Now, in order to solve a particular problem, what you have to do is to be able to identify what the problem is that you're trying to solve. And the problem is essentially to create a government which is strong enough to do what you would like it to do, and not so strong so as to engage in the kinds of behaviors which will essentially destroy the very people whom it's intended to protect. Any descriptive political account of how governments are formed would come up with the rather melancholy conclusion that it's the exceptional society that survives. Most of them, in one form or another, break down into discord, revolution, and strife, and may have periods of relative peace, but will be punctuated by periods of serious disasters. There are entire places in the world where no coherent form of government has ever emerged, and the United States, which constitutes a very tiny percentage of the world's population, and a few of the Western democracies, are the major exceptions to those particular rules. Their internal governance structures differ in many ways, of course, and so the question is, can you figure out what the common elements are that they seem to understand, or at least at one time have understood, and see if you could put these things into a book. Now, to start with this thing, the problem then is how you control political discretion. It must be broad enough to allow central government tasks to be discharged. It cannot be so broad so as to allow one faction of the company or of the nation to simply run roughshod over the others. So you have to give it to government, and you have to constrain the government once it gets it. And I think the great writers like Hayek and Hume and Madison all understood this is the central problem. The weaknesses, I think, in their general interpretations were that they were not sufficiently attentive to the various mechanisms that could be used in order to achieve that end. And private property and the rule of law, in this particular account, fit together quite closely, but they must leave room for public administration in the way in which they are formed. So start for the second with the rule of law. And at this particular point, if you want to write an account of how the rule of law fits into the general scheme of political freedoms, what you have to do is to take a definition that you yourself do not invent for the occasion. And the best of the definitions is written by a man who never used the phrase, perhaps the greatest of American legal thinkers in mid-century, at least in retrospect, a man named Lon Fuller, who made major contributions to constitutional theory, jurisprudence, contract law, and so forth. He defined it as a series of procedural virtues, which had the kinds of things that everybody, regardless of political persuasion, will accept. And these are such things as no bias in determinations, notice of the various kinds of charges that would be given against you, clear and consistent rules implied by impartial judges to individuals who have notice of the particular charges that will be raised against them. And if you start to go around the political spectrum and try to find yourself who is opposed to that, there will be nobody within the American system who will announce this formal opposition to this, although you will find the odd Stalinist here and there who would think that these are all useless impediments to the great system of social justice as they see operated by machetes, lawnmowers, and worse. So that becomes the sort of template, and it's a very useless template. Now, the weakness in the Fuller formulation, as I've just given it, is it's very much directed, as most mid-century writings were, not to the basic structure and system of entitlements as we have it, but rather to how it is that you make the great administrative state work. And so Fuller was not trying to rail against the New Deal tradition or progressive tradition, not a particular classical liberal. He thought that all of these particular virtues that he had could coexist with respect to any substantive scheme of law and sort of temper down its particular excesses. And my view about that is ultimately it turns out that it fails. It's that if you start to create the wrong set of entitlements, the right set of procedures will not be able to save you. And so what you then have to do is to figure out, not as a definitional matter, which will persuade nobody, but as an analytical matter, how it is that you tie in the system of private property to the rule of law in a way that the two of them function better, each off the other. And essentially, I think what you can show fairly easily, so I won't dwell upon it, is if you have a system of private property, and then you have a series of disputes involving trespass and defamation and breach of contract and so forth, if you don't have the structures of the rule of law in force with respect to their treatment, you will never be able to get a coherent society. You will essentially find people routinely expropriated because the judicial system or the legislative system will not give them the kinds of protections, formal and substantive, that they need. But it's the other relationship that's much more difficult, which is to figure out why it is that when you want to keep the rule of law in the long run, you need to have the system of private property. So in order to do that, it'd be very useful to give some kind of definition as to what private property is, and to do so in a way which I think is not designed to make it some kind of mystical and reverential subject, but kind of descriptive, common sense, and functional. And I take no shame in the fact most of the influence that came on me with respect to this topic started very early in my Oxford career. I'm the only American law professor I'm aware of whose first quarter in law school was spent exclusively studying Roman law, and it had a very powerful influence on the way in which I start to think. So what is this definition of private property? Well, to give the short version of it means that you have to limit yourself to certain kinds of private property. It's not that you can't extend it, it just takes more work. So you start with land, you start with chattels, you start with animals, and in fact in Roman times you had this very awkward thing known as slavery, and you had to include that into the system. We'll put it aside, I think, for these particular purposes, and concentrate on the forms of property that have rightly endured. Now, what are these features? Well, first of all, you have to identify the race, that is the thing which is subject to property, and that's generally not going to be too difficult, except perhaps for land, where you have metes and bounds and time as the appropriate definitions for what it is. Then what you're trying to do is to figure out what is the